Hello, friends. I welcome you all in the Constitution Law lecture series. This is lecture number 7 in the Clat lecture series sponsored by Sri Jayendra Rank Institute, and I am Shekhar Gehlot, your mentor for the session. So today in this session, we will discuss about the union and state. See, we are discussing Constitution of India, and then we will discuss about what is provided for the union and the state in the Constitution of India. Okay, our Constitution provides for both state as well as union. Union, that is government at the center. State, that is state governments. Okay, so where do we find union or the state governments? How do they operate? What are their functions? Now we all know that there is a parliament, there has to be a president of India, we have a prime minister at the union level, then chief ministers at the state level. How do we know, or from where do they come from? They come from the Constitution of India, and Constitution does provide for all these functionaries and their relation and how will they function. Okay, so in this chapter we will discuss union executive and the state executive. Okay, like we all understand what is executive is. We understand executive is someone who's implementing the law. Okay, roughly we can say PM and cabinet for center, CM and cabinet for state. Okay, this is our state executive, this is our central executive. Then we'll discuss about union legislature and state legislature. Legislature, as we have already discussed, is the law making body, the body which makes the law. Okay, for center, law making body is Parliament of India. For state, law making body is state legislature. Okay, state legislature includes, like in parliament we know, it includes president plus Lok Sabha plus Rajya Sabha. Similarly, here it has governor plus legislative assembly, also known as Vidhan Sabha, and plus in some states we have legislative council as well. Okay, legislative council, which is known as Vidhan Parishad. Okay, so in Tamil Nadu we have Vidhan Parishad as well. Usually in other states we do not have any, we only have governor plus legislative assembly, that is Vidhan Sabha, but in some states we have Vidhan Parishad as well. Vidhan Parishad states are Gujarat, then Tamil Nadu, Maharashtra, then Uttar Pradesh, Hyderabad. Okay, these are the now Telangana as well. These are the states in which you have Vidhan Parishad. These are the states in which you have Vidhan Parishad, though Vidhan Parishad is not a mandatory feature which has to be there, but it's an institution which is functioning in some states and not functioning in other states. It hardly makes a difference. Even if Vidhan Parishad is not there in some states, like in major states we don't have Vidhan Parishad, then also there is no particular issue, constitutional issue with that. In other states we have state legislature which is comprised by governor plus legislative assemblies only. Then we'll do union judiciary and state judiciary. Okay, judiciary is the judicial wing, dispute settlement wing. At the union level, we have Supreme Court of India. At the state level, we have respective state high courts. Okay, so we'll try to understand what these all organs of governments are at different levels, union and state level, in these lectures. So let's begin with the union executive. So when we are discussing about the union executive, the first and foremost executive for the union is the president of India. Okay, now some people may be confused that why I did not write, when I write executive here, I write only PM and cabinet or CM and cabinet. I do not mention president in the list of executive. Okay, see, the president is chief executive. President is chief executive of India, but theoretically, only theoretically. In practically, only the PM and cabinet or the CM and cabinet are the real executive. They have the power to execute the law. Okay, he is only a constitutional head. President of India is only a constitutional head. He has not much executive powers. All the executive powers, all executive powers are exercised in the name of president, but they rest with PM and cabinet. Okay, though all the executive powers are exercised in the name of president, but but he is the real executive of India is prime minister and the cabinet. Okay, he is only a president, can only be called as a mere or a rubber stamp. Rubber stamp here means that he has not much power, but only he is a stamping authority. Whatever PM and cabinet are doing, he just stamps it. He just put a stamp of approval on that particular decision, and he does not have too much powers to refuse to accede to what PM and cabinet have decided. Okay, so President of India is the chief executive. He is the constitutional head only, like I just described to you people why he is only a constitutional head. Why? Because the real head is prime minister and the cabinet. All business of government of India to be carried out in the name of the president only. He administers oath to the prime minister and the council of ministers. So when new prime minister or the council of minister is set up or they come into power, he is the one, president is the one who administers oath to the prime minister and the council of ministers. Okay, these are some of the powers of President of India. He can dismiss any minister upon advice of the PM. So the one who is appointing, the one who appoints can only be the one who can dismiss. Okay, so the one who appoints can only be the one who dismiss. Now we know that he is administering the oath to the prime minister and the council of ministers. So he is the one, president of India is the one who appoints the prime minister and the council of ministers, and he only can dismiss any minister on the advice of PM. Prime minister straight away himself cannot dismiss a minister. Okay, if he wants to dismiss a minister from his cabinet, uh, and the minister is refusing to resign, then the prime minister will simply make a recommendation to the president of India, and the president of India then will, on the advice of acting on the advice of PM, will dismiss the minister. He can dismiss PM if he loses trust of what? Yes, he can even dismiss the prime minister if he loses trust of what? Trust of what is a feature, a safeguard, kind of a safeguard, constitutional safeguard. Okay, when the PM is not functioning as per the requirements of the parliament, then the both sessions of both houses of the parliament will go for a, not both houses, sorry, only Lok Sabha will have a trust vote, also known as confidence motion, also known as no trust motion. Okay, also known as no trust motion. So they will bring a no trust motion that we do not have a that the parliament does not have trust in the PM, or other way we can say the PM does not have the trust of parliament. So here in the parliament, in this particular case, trust motion can happen only in the Lok Sabha or for CM in Vidhan Sabha. So this no trust motion, if this no trust motion is passed, okay, by majority of members, if the majority of members, more than 50% members say that we do not have trust in the Prime Minister, then the President will dismiss the Prime Minister as well. He is also referred to the first citizen of India. This is an honorary tag given to the President of India. It literally does not give him any such power or privileges. He can dissolve the Lok Sabha upon the advice of Prime Minister. So he can dissolve the Lok Sabha. Or if we talk about governor at the state, Prime Minister can dismiss Lok Sabha but only on advice of PM and his cabinet. Okay, if the PM and the cabinet feels that Lok Sabha has to be dissolved, then the the President of India will dissolve the Lok Sabha and fresh elections will be called. Okay, fresh elections will be called. Going back to this no trust motion, very recently we saw no trust motions against the CM of Madhya Pradesh, that is Kamal Nath, and he lost there. And he had to give up his government, and the new CM Shivraj Singh Chauhan was sworn in because he now enjoyed the trust of the Vidhan Sabha. Okay, fresh elections will be called, and similarly a governor of state could dismiss state assembly upon advice of CM and cabinet. Okay, so whatever roles the President of India is functioning, okay, vis-a-vis in relation to union, the governor of any state carries out those functions in relation to the state government. Okay, so if you want to understand about the governor of India or governor of a state, we can replace the president with the governor and union with the state. Similar functions are carried out by the governor in relation to a state. He can proclaim emergency at national, state and financial level upon written recommendation of Prime Minister or a Chief Minister. This Chief Minister should not be here, sorry. So the President of India has the power to proclaim emergency at national, state and financial level upon written recommendation of the Prime Minister of India. Now what is this emergency and what is the emergency of national, state and financial level, we will discuss later on, but we must just understand the power of President of India. He only has the power. Here if we compare him with the governor has no such powers in relation to state. Okay, governor has no such powers. Governor cannot proclaim emergency in the state. Only power is governor could recommend for emergency in his state to the President of India. Okay, only power governor has in respect to state is that he can recommend that there has to be an emergency in my particular state to the President of India, and then President may or may not agree. No bill can become act unless the president gives his assent except the money bill. Okay, so this is the law making power of President of India. No bill will become a law unless it receives the assent of president. Assent means signature, or may say approval. Usually the approval is given in the terms of signature only. When the president will sign a bill, only then the bill will become a law, or when a governor will sign a bill, when a governor will sign a bill in the state, then only that bill will become a law in the state. Okay, except money bill. Money bill has been given a very special place in the Constitution of India. So any money bill passed by the Lok Sabha and then by the Rajya Sabha will automatically come into operation, and president has to, it will take his assent. See, the issue is no bill can become act unless president gives his assent. In this case, sometimes president may refuse to give his assent. In regular bills, president may say, no, I do not approve this particular bill. Okay, but in the case of money bill, when the money bill has been passed by the President of India, by the Lok Sabha and Rajya Sabha, the President has no power. President has to give his approval, and he is bound. Okay, in case of a money bill only, President or Governor is bound to approve it. Okay, because this is a special bill. Otherwise, in a regular bill, see, this is what we discussed about the money bill. President's powers in respect to money bill, he is bound. But in regular bills, in other laws, okay, regular bills are those which are not financial bills. Simply, it is stated in the Constitution. Regular bill is ordinary bill, regular bill, or common bill is which is not a money bill. Okay, so in regular bills, president can only once send the bill back. If the bill again reaches president with or without modification, he has no option than to give his assent. So suppose now Lok Sabha and Rajya Sabha send a bill. Now we are discussing farmers bill. Suppose now let us take the example of farmers bill at union. Okay, now it has been passed by both Rajya Sabha plus Lok Sabha. Now this bill will go to president. President can at this stage, at one stage, refuse to sign it, refuse to approve it. Okay, when the president refuses to approve a bill, then the bill will again go back to both the houses. Okay, again go back to both the houses. At this stage, president may also make recommendations. President may also make recommendations. While refusing to approve the bill is, when he refuses to approve the bill, it is called the bill is sent back to the houses. When sending the bill back to the houses, president may also make recommendations that you should remove this or you should add this into the bill. And if now in this time, if the LS Lok Sabha plus Rajya Sabha resend the bill back to president, then president has no other option than to approve the bill with or without modification. Okay, so here we discussed that while refusing to approve or sending the bill back to the houses of the parliament, president may also make some recommendations. But if Lok Sabha or Rajya Sabha resend the bill with or without modification, they may accept to the modifications suggested by the President of India, or they may not. They may go with the original bill. They may again pass the original bill and send it back to the President. Then President has no option, compelled, no option other than to approve it. Okay, this is one option given to the president, that in his wisdom may send the bill back to the houses and may also suggest some modifications. But if the house chooses to go with the original bill, or may make some of the modifications suggested by the parliament and not all the modification, and send it back to the president after passing it, then president has no option than to approve it. This is done to ensure rule of people. Okay, this is done to ensure that India is ruled by the people. Why people? Because Lok Sabha and Rajya Sabha represent the collective representatives of the people of India. The MPs in Lok Sabha and the MPs of Rajya Sabha are the representative of the people of India. So when the people of India want a law to be approved in this particular original form, then president has no option. Okay, he will have to approve the bill, whatever he will have to accept to the will of the people of India. However, he could withhold his assent and keep the bill pending with him for any number of days, months, or years. But now see, now president is bound to sign, bound to approve bill. Now the president is bound to approve a bill, okay, but we cannot compel the president, or no one could compel the president to decide the time of signing a bill. Okay, to decide the time of signing a bill. He may refuse, or because the person is free, the president of India cannot be compelled that you sit on the table and sign the bill today only, or tomorrow, or day after tomorrow. He'll take his own sweet time, and he may not even sign it for years. Okay, he may not even sign it for years. In that case, that bill will remain a bill only. It will not become a law. So now, suppose farmers' bill is sent back to the both houses of parliament by making some modifications or some recommendations by the president of India. But what the both houses do, they resend the original bill without making any changes as suggested by the president of India. They send it back to the president to sign it. Now the president of India has no other option than to approve it. Okay, he has to approve it. Why? Because we are ensuring the rule of people. But only way out for the president here is, if he does not wish to approve this bill, he cannot refuse to sign, but only way is he can withhold. Okay, he can take his own time. He may decide to sign it after some months or after some years. We cannot compel the president of India to sit and sign the bill right away. Okay, so this is the only power which the president has in relation to the ordinary bill. In relation to the money bill, president cannot take his own time like this. He'll have to sign it within some days. He can convene a joint session of parliament. Okay, president can convene a joint session of parliament as well. We'll discuss about this joint session of the parliament later. These are his powers. When parliament is not in session, he can promulgate the ordinance. This is the law-making power of the parliament, or the president. Okay, these are the law-making powers of the president at the union and the governor of a state when the house is not in session. See, the parliament or the state legislature, they only function when they are in session. Okay, and we have very limited sessions, 3 sessions of the parliament and the state assemblies in India per year. So sometimes when parliament is not in session, we know bills are passed by the parliament, both houses, Lok Sabha plus Rajya Sabha, and they will pass it only when they are sitting together. They are sitting as a house and they sit as a house only during session. So suppose right now the session is not going on, so we cannot expect all the members to be sitting collectively. So, and there is some emergency situation and some law has to be passed by the parliament. But because parliament is not in session, in that case, this president of India can promulgate ordinances. Okay, he'll make a law which is called ordinance. It is called ordinance and it is valid only for 6 months. Okay, 6 months validity only. He'll pass that law and that law will become operational from the date of promulgation of the ordinance, and it will remain valid only for 6 months. Why? Because within 6 months session of the parliament will be convened and then parliament will decide whether to make this ordinance a law or not. If the parliament refuses to accept this and make this a law, ordinance will lapse, or if the parliament does not take any decision, then also ordinance will lapse. 6 months validity afterwards needs approval of parliament or state assembly, else ordinance shall lapse. Ordinance once promulgated once promulgated becomes law immediately. Okay, when an ordinance is promulgated by the president or the governor, it becomes law immediately, but only for 6 months. After those 6 months, either the state assembly or the parliament will have to approve it, otherwise the ordinance will lapse or the law will be set aside. Another power is he appoints the judges of Supreme Court of India, High Courts, election commissioners, CAG, that is also Comptroller Auditor General of India. Comptroller Auditor General of India, members of UPSC, ambassadors and diplomatic agents to the foreign countries, governors of the state, lieutenant governors of the states, members of SC, ST, OBC commissions, and other important constitutional functionaries. He'll appoint them. He is the supreme commander of the Indian Armed Forces and can declare war and peace. This power is exercised alone by the president. Alone and not by governors in relation to states. Okay, a governor does not have any control over the armed forces, only the president has the control over the armed forces. We have three armed forces, that is Air Force, Navy and Army. He is the supreme commander of Indian armed forces and he is only person who can declare war with some country. Like we are discussing, reading newspapers nowadays, that India is at war, not at war, but India is at loggerheads with the China at the Ladakh outskirts. So tomorrow, suppose we have to declare a war with the China, only president is competent person. He is the supreme commander. He will declare war, and when there is a war, only he is the person who can declare peace as well. Okay. So these power rest exclusively with the president of India. That is why you will see always whenever president of India is appearing anywhere, he is always accompanied by the commanders of three forces. He is always accompanied by 3 4 people in different uniform. You can see someone wearing white, someone wearing sky blue, someone wearing green. This signifies that the members of Indian Armed Forces are always at duty to protect their own supreme commander. He summons, addresses and prorogues the parliament. He will summon the parliament. So whenever parliament is not in session, then parliament will come into session only when president wants it to sit together. He summons the parliament. Okay, he'll summon the parliament, Lok Sabha and Rajya Sabha, to come and sit together. He addresses the parliament every year beginning, president addresses. Parliament and governor the state assembly. Okay, governor will address the state assembly, president will address the parliament, and he can prorogue the parliament, that he can cancel a session. Okay, he can cancel a session, president for the union and the governor for the state, they can cancel or recall a session as well. He can grant pardons, reprieves, respites, or remissions of punishment. Okay, Parliament, President can grant pardon. Pardon means uh, excusing someone. Okay, excusing someone, or giving freedom to someone, or we can say providing freedom to someone, freedom from prosecution or the sentence. He can grant pardons, okay, up to death sentence. Any sentence, we may say, any sentence could be pardoned. Any sentence could be pardoned by the President of India. Suppose X is sentenced to death. President may grant him freedom. Okay, that is called pardon. When he grants absolute freedom, it is called pardon. Or he may provide remission, respite, or reprieves. He may provide remission, like he may convert death sentence to life imprisonment. That is called remission. Okay, or he may also provide some breaks. That sentence will not operate for 2 years. 2 years break, that will qualify as reprieve or respite. Okay, so president is empowered to do so. Similar power is enjoyed by governor of state other than death penalty. Governor of the state has all the powers exercised by the President of India to grant pardon, reprieve, respite, remissions of punishments other than death penalty. When someone like X is sentenced to death penalty, then only President may grant him power. Governor has no power in this case. When someone is sent to death penalty, Governor has no power over this person to grant him pardon, reprieve, respite, remission, etc. Only President will be competent authority. However, the real head in a democratic form of governance is the Prime Minister and his Council of Ministers. Qualifications of the President of India: he must be a citizen of India, definitely. He must have completed 35 years of age. He must be qualified for election as a member of the House of People. He must not hold any office of profit under Government of India or the state government. Okay, so he must be a citizen of India. Minimum age has to be there because we want a president to be a bit mature and wise person. So 35 years of age, must be qualified for election as a member of House of the People, that is Lok Sabha. He must be qualified to become a member of Lok Sabha. It is not that he must be a member of Lok Sabha. No, he should only be qualified for becoming a member of House of People. He should have qualifications. Okay, not that he should be. If he is a member of any house, he'll have to resign if he wants to become a president of India. He must not hold any office of profit under Government of India or state government. Office of profit simply means he should not be under the services. He should not be under the services of state or union. Now, similar is with the case of governor. Similar is the case with the governor. Governor should be citizen of India. He should also be minimum 35 years of age. He should also be qualified for the election of Here we have member of House of People. There it would be, for governor it would be member of Legislative Assembly. So governor should be qualified to become a member of Legislative Assembly. I am again repeating, he will not be a member of Legislative Assembly, but only he should be qualified. Okay, and similarly, governor should also not hold any office of profit under Government of India. Election to the President of India. First of all, before going to the election to the President of India, let us understand election to the governor. Governor has no elections, no election procedure. Straight away appointment by President of India. Okay, anyone who fulfills these qualification can be made a governor of any state by the President of India. Governor does not need to have any election procedure followed. There is no procedure laid down in the constitution. President will straight away make anyone, his desired person, as a governor of particular state. Election to the President of India. The President of India is elected by the members of an electoral college consisting of. See, the election of President of India is done by a college that is called Electoral College. Okay, that college, like every college or school, we have students, college, we have students. In this electoral college, we have electing members. Electing members are elected members of the both houses of the parliament. Elected members of both houses of parliament, that means Lok Sabha plus Rajya Sabha, and elected members of the legislative assemblies of the state, that is legislative assembly plus, if any state has it, legislative council. Okay, Vidhan Sabha, Vidhan Parishad. If some state does not have legislative council or Vidhan Parishad, like we discussed earlier, that only legislative assembly. So the elected members of these uh, houses, Lok Sabha, Rajya Sabha plus Legislative Assembly, they people constitute the electoral college. All these members will become electoral college, and then they will vote, and as per the counting of votes, President of India is elected. Now we should understand that only elected members of the both houses or elected members of legislative assemblies shall be eligible to vote. Nominated members shall not vote. Okay, there are some members in all the houses, like in Lok Sabha, Rajya Sabha, or legislative assemblies. We have some members which are nominated and not elected. They do not have right to vote, like Sachin Tendulkar was a member of Rajya Sabha. He was a nominated member of Rajya Sabha. Okay, so when the elections to the President of India, that is Shri Pranab Mukherjee, was happening, Sachin Tendulkar was not eligible to vote. He was, because he was not a part of electoral college. Okay, therefore he could not vote. Why he could not vote? Because he was a nominated members. And why nominated members are not eligible to vote is because these members are not elected. These members are elected by the people of India directly. These members are not elected by people of India. They are nominated by the president only. So we want, India is a republic country. That means the head of the India, that is the president of India, shall be elected by the people of India. So people of India will speak only through their elected members of parliament or elected members of legislative assemblies. These members have been elected directly by the people, so only they can cast their vote in the election of president of India. This nominated member has no relation with the public. Public has not decided whether this member should represent them or not. That is why they are not entitled to vote, because India is a pure republic country. Terms of office, uh, 5 years, and is re-eligible for election. Okay, from the date he enters into the office, a president is entitled to stay in the office for 5 years, and he is even eligible for re-election. Okay, like Rajendra Prasad, Dr. Rajendra Prasad was re-elected. Okay, he got 2 terms as the president of India, and same is with the governor's duration is usually 5 years, and he is also re-eligible for appointment. We will not say eligible for re-election, because he is not elected. Governor is not elected. Governor is also for 5 years, 5 years or unless removed by President of India. Usually, a governor will enjoy a tenure of 5 years unless removed by the President of India, or President of India may remove him before these 5 years as well. Okay, that is up to the President of India, and governor is also eligible for re-nomination. Okay, not re-election, because governor is nominated, or appointment by the President of India. Now we come to another important aspect, that is removal of the President of India. How the President of India could be removed? This process is called impeachment, process of impeachment. So see, President of India holds a very important position in the Indian democratic system, and so that to ensure that president has a security of tenure, and no one could blackmail him. No one could, or no government could blackmail him with his tenure. That is why he is given a very difficult procedure for removal, that is called impeachment. Okay, so that tomorrow a government may not compel a President of India to sign a particular bill, just because otherwise they will threaten the president that we will remove you. Okay, so that there is no threat of blackmailing of any kind over the President of India. His removal is very difficult, because one of the ways to blackmail someone is by threat of removal from the office. Okay, so the President of India can be removed, that is by process called impeachment. And impeachment, the stages of impeachment are this. And impeachment will happen only for the violation of the Constitution of India. If the president is found to have violated any provision of the Constitution of India, then only this process of impeachment will start. Otherwise he cannot be, this impeachment can also not be started. Okay, suppose president not having good relation with family. Okay, he is not having good relations with the family, then impeachment cannot be started, because Constitution of India's provision has not been violated here. Okay, that is his personal matter. Okay, so the process of impeachment of Indian president is this. First stage, either house initiates impeachment motion with at least one-fourth members signing the impeachment motion and submitting it with the chairman speaker of the house. 14 days notice is given to the president. Okay, so in the first stage, either house, either Rajya Sabha or the Lok Sabha, will initiate impeachment motion with at least one-fourth members signing. Okay, so at least one-fourth members will sign over it. Like in Rajya Sabha, we have 250 members, so roughly 75 members will sign it, and in Lok Sabha we have 553 members, so at least 150 members are required to sign an impeachment motion. Okay, then only impeachment motion will be put in process, and then they will submit it to the chairman or the president of the house. Okay, it will be submitted to the, suppose it is originating in the Rajya Sabha, then it will go to the chairman, because the president of the Rajya Sabha is called chairman. And if it goes to the Lok Sabha, then speaker, because the moderator of the Lok Sabha is called speaker of the house. 14 days notice is given to the president can give reply to this impeachment motion within these 14 days if he wishes to. Then after these 14 days are complete and president does not give reply, or if he has given the reply, then at the stage 2, the chairman of the speaker of the respective house, either Lok Sabha or Rajya Sabha, where motion originated, will decide if house should proceed. Now the power comes to chairman or the speaker of the Lok Sabha or Rajya Sabha. Now the chairman of Lok Sabha or Rajya Sabha will read this impeachment motion. Okay, and they will also consider and reply if so given by the President of India, and then they will decide whether house should proceed or not. Okay, if chairman or speaker decides that House should not proceed, the impeachment will fall. Okay, so first stage is one-fourth members will sign the impeachment motion. They will write what grievance they have with the president or what provision of the constitution president of India has violated in their opinion, and then they will give a 14 days notice to the president, and then they will submit it to chairman or speaker. Then the chairman or speaker will decide after reading all this thing that whether the house should proceed on this particular motion, and if he comes to the conclusion that the president of India has not violated any constitutional law in his opinion, then he will decide that house should not proceed and the impeachment motion will fall. But suppose he decides that house should proceed, then what is the procedure? Then, if allowed by the chairman speaker, the house shall vote over the motion and pass it with two-thirds special majority of the total membership, called special majority. This majority, two-third majority, means more than 75% votes. Okay, more than 75% MPs should vote in the favor in that particular house. That is called special majority, and then it will pass from that particular house. Okay, one house, suppose Rajya Sabha passes it with special majority, then it will go to the Lok Sabha or Rajya Sabha as per the case may be. Then this house will investigate the charges. Okay, this house will investigate the charges, and president may represent himself here in the second house, or he may be represented by his chosen person. Okay, then if this house also passes with 75% special majority, 75% of MPs, then the president stands removed on the date of passing of such resolution. This is the process of impeachment, and no president has ever been impeached in India. No president of India has ever been impeached. Now we come to the Vice President of India. The qualification of Vice President of India is that he must be a citizen of India, must have completed 35 years of age, must be eligible to become the member of Rajya Sabha. Why member of Rajya Sabha? Because he becomes the chairman of the Rajya Sabha. Vice President of India is only the chairman of Rajya Sabha. Here we have no counterpart. Like in state, like in union, we have a vice president. In state, we have no vice governor. No provision of vice governor. We only have a governor. We may have lieutenant governors for UTs, but they are just like governor only. Okay, so there is no vice governor like vice president. So vice president of India, these are the qualifications for vice president. Elections by the members of the both houses through a secret ballot and single transferable vote. His election takes place in which both the members of the houses, Lok Sabha, Rajya Sabha, people will sit, and then they will cast one vote each, and if he wins, whatever member wins, he will be elected as Vice President of India. The term of office of Vice President is 5 years and is re-eligible for election, like we have seen Dr. Hamid Ansari was VP of India for 2 terms 2007 to 12 and 2012 to 17. Okay, Professor Hamid Ansari was re-elected for 2 terms. Removal can happen only resolution passed by adopted by majority of members of Rajya Sabha, resolution passed by the majority of members of Lok Sabha. Okay, so he can his removal is not as difficult as the President of India. His removal is quite easy, like resolution, because he is a chairman of Rajya Sabha, so his removal resolution will always originate in Rajya Sabha only. So in his case we do not need a special majority, only simple majority, which is also called 50% plus. Okay, 50% plus members of the Rajya Sabha feels that he should be removed, then they will, after passing of this resolution, they will send the resolution to the Lok Sabha, and 50% of 50% plus members of the Lok Sabha also feels that he should be removed, then he will be removed. This is the removal of the Vice President of India. His functions are, he acts as the chairman of the Rajya Sabha, just like Speaker of the Lok Sabha. He is the chairman, or the, we can say unofficially we can say Speaker of the Rajya Sabha as well, and he acts as the president during his absence. When the President of India is not available, he will act as the President of India, like V.V. Giri once functioned. Okay, V.V. Giri once functioned as acting president of India because he was the vice president and then president had expired. Now we will discuss about the Prime Minister of India and Deputy Prime Minister and other ministers. Okay, the Prime Minister shall be appointed by the President and the other ministers shall be appointed by the President on the advice of the Prime Minister, like we already discussed. The total number of ministers, including the Prime Minister in the Council of Ministers, shall not exceed 15% of the total number of members of the House of People. Maximum size of cabinet. Okay, that is PM plus ministers becomes a cabinet. Okay, maximum size of cabinet is 15% of strength. 15% of strength. Okay, so in Rajya Sabha and Lok Sabha we have roughly 250, we have roughly 700 800 members, so 800, like we can have maximum 100 ministers at state, at center. Okay, including Prime Minister, we have maximum 100, around, it comes out to around 125 ministers at center including Prime Minister, and same is with the state. Okay, maximum number of cabinet, maximum size of cabinet can be 15% of the total number of members of the okay, House of People, sorry. So here we go 553, so roughly 75% we can, 75 ministers we can have, and same is with the state government. Sorry, please excuse me, only House of People shall be counted, Rajya Sabha members shall not be counted for it. The minister shall hold office during the pleasure of the president. That means whenever president wants to remove a minister, he can remove him. Okay, but it is not like this. He should get a recommendation from the Prime Minister. The Council of Ministers shall be collectively responsible to the House of People. The Council of Ministers, that is called Cabinet, shall be collectively responsible to the House of People. That means they shall be responsible to the House of People, and the House of People want to remove them, then they can remove the Council of Ministers by a no trust motion, no confidence motion, like we have discussed earlier. Before a minister enters upon his office, the president shall administer to him the oath of office and secrecy according to the forms set out in the purpose of third schedule. A minister who for any period of 6 consecutive months is not a member of either house of the parliament shall at the expiration of that period ceases to be a minister. That means you can become a minister See, the qualification for the prime minister and the minister are same. Okay, that they should be chosen member from the Lok Sabha or Rajya Sabha. Okay, either they should be a member of either Lok Sabha or a Rajya Sabha to become a minister, and for the CM, the state assembly or the state legislature, state council. Okay, but suppose now one wants to become a PM. Okay, and he is not a member of any of the house, he is not a member of Rajya Sabha or the Lok Sabha, then also he could be sworn as the prime minister. That means we can have a prime minister or a chief minister or a minister at the state or union who is not a member of either house, but that is valid only for 6 months, and after the expiry of 6 months, within those 6 months, he should himself get elected himself to either house, either to the Rajya Sabha or Lok Sabha. Otherwise his nomination will come to a halt and he will be removed. Like Shibu Soren became CM of Jharkhand without election, and after 6 months he could not get himself elected to state assembly and he had to resign because he lost his election to an independent candidate. Similar is the case with Uddhav Thackeray, recently became CM of Maharashtra without being a member of House, but later became a member of Legislative Council. Okay, within the 6 months, Uddhav Thackeray became a member of Legislative Council because Maharashtra has a Legislative Council, and that is why he is still continuing as the Chief Minister. However, Shibu Soren did not have this particular opportunity because Jharkhand does not have a legislative council, it only has a legislative assembly. So he became a chief minister and then he went to election for a particular seat, but he lost there, and that is why he had to resign. And the Prime Minister Manmohan Singh is a famous example for being a Prime Minister who came from the Rajya Sabha and not from the Lok Sabha. Usually Prime Ministers have always come from the Lok Sabha, House of the People. Qualifications for the Prime Minister, Minister or Deputy Prime Ministers are all same. He has to be citizen of India, must have completed 25 years of age. If he is a member of Lok Sabha, yes, a 25-year-old person can become a Prime Minister or Minister of India if he is a member of Lok Sabha, and he must have completed 30 years of age if he is a member of Rajya Sabha. Why? Because for being a member of Rajya Sabha, minimum age is 30 years. For being a member of Lok Sabha, minimum age is 25 years. So there are not much qualifications for PM or Deputy PM or ministers. No education qualification as such. Only that he should be a citizen of India, and he should be he should be 25 years if he is a member of Lok Sabha. He should be minimum 30 years if he is coming from the Rajya Sabha, like Dr. Manmohan Singh. Election process of ministers, chief ministers or prime minister of India is same. Ruling party members elect their leaders through elections within the party. Suppose now the BJP party has come into power, then BJP members will sit and decide who is going to be their leader of the party. They decide Narendra Modi is going to be the leader of the party. Now Narendra Modi will become the prime minister of India. No separate election procedure is required for being the prime minister of India. Then there is terms of office of these minister, prime minister or chief ministers, 5 years from the date of election unless dismissed. Okay, they could be dismissed. We discussed that if no trust motion is there or no confidence motion is there, then they will be dismissed. Okay, or Lok Sabha is dissolved. When the Lok Sabha is dissolved, like we discussed, prime minister or chief minister can recommend to the governor or the president that for dissolution of Lok Sabha or the state legislature, then the president of this prime minister or ministers or chief minister will have to vacate the office, and they are also eligible for re-election like Prime Minister Modi or Prime Minister Manmohan Singh. They came back to the office once again. Removal can be removed by the President of India upon recommendation of the ruling party. No confidence motion passed by the Lok Sabha. Okay, when the ruling party, suppose BJP today convenes a house of the BJP members and they all vote in favor of removal of Modi as a prime minister, then the president will remove Modi from prime ministership. Okay, or when there is a no confidence motion passed by the Lok Sabha or state legislature for the CM or state ministers. Functions is their functions are function only written function in the the Constitution of India is functions at the head executive of India and implements the laws passed by the parliament. He is the head executive of India, like we discussed. The prime minister or the president of India is the chief executive, okay, but he is only a chief executive in the name. Real head executive of India is the prime minister and other ministers, his fellow ministers, and they implement the law passed by the parliament. Whatever law is passed by the parliament or the state legislative, the PM and the CM shall take care of the implementation of that particular law.